Hey guys, welcome back to my channel, Down the Rabbit Hole News. I am the Rabbit. Shout out to everybody in the chat. I came across this video by a creator by the name of Brian Tyler Conan. Now, I'm new to his commentary, and he brought in a lawyer to talk about this situation with Pam Bondi and Trump and the grand jury transcripts.
Glenn, the Epstein pressure is very clearly getting to Trump because he just had to offer a concession up to his audience. He took to Truth Social writing, based on the ridiculous amount of publicity given to Jeffrey Epstein, I have asked Attorney General Pam Bondi to produce any and all pertinent grand jury testimony subject to court approval. This scam perpetuated by the Democrats should end right now. And then Pam Bondi chimed in and said, President Trump, we are ready to move the court tomorrow to unseal the grand jury transcripts. And so again,
and we all saw that play out yesterday.
Trying to offer up the optics that they're giving a concession, but can you dig into what this actually means, that they're focusing on grand jury testimony, that they're focusing on pertinent testimony? Will we be getting all of the information that we were promised?
You know, we may be getting exactly zero information because the court would have to order the release of grand jury transcripts. This feels
so this is very much just appeasing to a couple of people that are really buying into this idea that we might actually get this information.
More like a Hollywood production, maybe another episode of The Apprentice, right? This is a reality show. It's not, in fact, reality. And here's why, Brian. First of all, we have to start with the rules that govern grand jury transcripts and all grand jury materials. It's Federal Rule of Criminal Procedure 6E. Here's what it stands for.
Okay, so I did pull up federal rule. The Federal Rule of Criminal Procedure 6E governs the secrecy of grand jury proceedings. It generally prohibits the disclosure of matters occurring before the grand jury. This includes testimony, documents, and other information related to the grand jury's investigation. Exceptions exist, such as disclosure to government attorneys for their duties or when authorized by the court. So the rule here, to give you more of a breakdown, and this is per AI, the rule aims to protect the integrity of the grand jury proceedings by keeping them secret. The secrecy prevents witnesses from being intimidated, protects the reputation of those who are investigated but not indicted, and encourages full and frank testimony. Who is covered under that secrecy rule? Grand jurors, court reporters, interpreters, and government attorneys are all bound by the secrecy requirement. It further goes, witnesses are generally not subject to the same secrecy restrictions and can disclose their own testimony to others. Now, what is considered a matter occurring before the grand jury? This is broadly interpreted to include anything that would reveal what took place in the grand jury deliberations or investigation. This can include transcripts of testimony, exhibits presented, and even the fact that a particular document was presented to the grand jury. And let me keep going with this video because I really like the way he breaks this down.
Grand jury information. That means witness testimony, records that are produced pursuant to grand jury subpoenas, telephone records, photographs, videotapes, you name it. It is all protected by grand jury secrecy. And here's what everybody needs to know. The rules only provide that a court, a judge, may order the release of grand jury materials for only very specific and limited reasons. And I've lived this for decades. So, for example, I'm prosecuting somebody. I'm putting witnesses before the grand jury and they say, oh, you know what? The target of this investigation not only killed somebody in D.C., but he killed somebody in Maryland and he killed somebody in Virginia as well. That was our lived experience in the D.C. sniper case. And so what we would do, we would go to the judge, we would file a motion to seek permission to release those grand jury transcripts, that witness testimony, to whom? Law enforcement authorities, police and prosecutors in Maryland and in Virginia. That's one of the very limited reasons, lawful reasons, to ask a judge to release grand jury materials. You can read the rules, the grand jury rules, 6E, forward and backward, and nowhere in there, Brian, is The authorized release for public relations.
Pay attention to this. The authorized release for public relations. So it's very specific and geared. So is this going to be a nothing burger? Like, clearly, I myself, I'll speak for myself. I'm very much interested in wanting to get whatever information is out there that they're willing to release. But last time I checked, I would be considered public relations. You guys would be considered the public, right?
Purposes or in the public interest. It doesn't exist. So this is a hollow promise. This is nothing more than Donald Trump, using this as a pretext to try to claim, look, I'm being transparent.
Right.
No, you're not, because the rules don't provide for release of grand jury materials under these circumstances. Now, let me hasten to add.
We're not going to get anything. Okay? It's very specific to what the rule applies to. I mean, I don't know. Or maybe we are. I could be wrong. But the way in which this person is explaining it, this attorney, clearly it sounds like it's not going to be anything that, I don't know if we're going to get anything, or if because of the process that they're going about it, it's going to take longer. Longer.
There are some federal circuits that have decided, even though it doesn't appear anywhere in the rules of criminal procedure or in the laws, that judges can release things in exceptional circumstances when there is a searing public interest. Let me say, some federal circuits have said, you know what? We think because the grand jury is actually a product of the courts, the prosecutors don't control the grand jury, notwithstanding, I think, the popular belief that we could get the grand jury to indict a ham sandwich. It's actually overseen and orchestrated by and controlled by the judges, the courts. So some judges have said, I think, even though the rules don't provide for it, I have the inherent authority in my capacity as overseeing the grand jury to order the release of grand jury materials in exceptional or unusual circumstances if it is in the public interest to do so.
Okay, so there's some wiggle room.
So there's a split in the circuits. So I'm not saying it's impossible. Some judges might be willing to do it, even though the rules don't support it. But in this circumstance, Brian, when you just read what Donald Trump said and how Pam Bondi responded, what's pertinent? Okay, well, Pam Bondi might say, well, what's pertinent is anything that might incriminate anybody other than Donald Trump. Or
that's what we've been saying, guys. That's what we've been saying. Like, we were talking about it earlier in the live. We said, well, what is considered pertinent? Is it going to be people that he considers friends? What is pertinent to this president? What is pertinent? What does that even mean? Are they going to go through this and say, well, this person is associated to Trump, this is pertinent or not pertinent? Who decides what this even means? And this is where the word games and that they're playing with this is just ridiculous.
What's pertinent is anything that might make a Democrat look bad. Ooh, I deem that to be pertinent. So let me ask
and this is the thing, is that give them the opportunity to make somebody look bad all the time, or throw shade at somebody, or discredit somebody. I mean, Donald Trump will do it because that's what he does.
The judge to release that bit of grand jury information. All of this is for show. None of it, in my opinion, is for substance, and it's very unlikely to produce much of anything.
And that's the part I wanted to dig in on, the part that you had mentioned at the end, because let's grant the administration that this actually works. Maybe they look at the fact that, Jeffrey Epstein is dead, so there's no prejudice, there's no harm to his reputation. And so let's say a court does opt to grant the grand jury transcripts over to the Trump administration. There's nothing stopping them from just only picking what they want to expose while secreting the rest of that. Is that correct?
Exactly. And think about this. Not everything that prosecutors come into possession of during a criminal investigation is necessarily grand jury material. For example, somebody could conduct a search warrant and get all kinds of incriminating videotapes from, the Jeffrey Epstein's island. And that's not grand jury material. So that literally has nothing to do with what Donald Trump just posted, saying, I'm directing Pam Bondi to, release pertinent grand jury material. There are so many games that are being played here, semantic games and otherwise, that, I think this is all for show.
Glenn, can you talk about what the grand jury
I think that I would agree. All of this is for show, and I just don't think that anything is going to get released. If he wanted to have done it, he would have done it already. If people wanted to release this information, they would have done it already, guys. And so what they're doing is they're just playing they're just playing in our heads about this. Some of this is just that. It's just a game in semantics. These people, that the Cash Patels, the Dan Bongino, all these people that would go on podcasts and do different things and whatnot and say the different things. I mean, they've changed their tune. They're not saying this anymore. Well, why? Because the election's over. They got everybody's vote, and so they lied. And this played right in front of everybody's eyes, and people fell for it.
information is versus what the rest of the files would be in the Epstein files. The grand jury testimony only accounts for some small percentage of the information contained within the broader file. Is that correct?
Well, and if that is the case, then what are we going to really, what are the transcripts for exactly? Why is it just the transcripts, and why is it pertinent information and not just all the files? Covering, of course, redacting victim information. Absolutely, but all the files.
That's correct. However, grand jury materials are far more expansive than that. And here's why. Anytime we issue a grand jury subpoena, it may be for witness testimony. So once that witness testifies before the grand jury, that's a secret proceeding by law, the transcript of that witness's testimony, clearly grand jury protected material. However, people should know some other things. When we subpoena somebody to the grand jury, we almost always will sit down with them in advance of their grand jury testimony in my office, for example, with an agent or a detective present to witness everything and document it. And we'll do a very, very long interview in advance of the grand jury because we want to make sure that this witness has relevant evidence to provide.
Well, guys, let me know what you guys think in the comments. That was just a short little commentary. I'm going to link the video, the full video, in the description box. I do really like that breakdown because I feel like people are holding their breath. And the reality is, I don't think that's going to be the case at all. I just don't understand what people thought was going to happen. And maybe I could be wrong. I don't know, they might release something, but what they're offering just doesn't sound right. And it just sounds off. And it sounds like such a hollow promise. The word pertinent is something that is one that we can't let go. And so what is this a genuine, is there a genuine intention from this administration to release the information that a lot of people are wanting to know? We're going to keep following this. Let me know what you guys think in the comments, and I'll see you guys on the next one. Rabbits out. Bye, guys.